my regular admonishment from Howard Fisher. You guys never leave me any space. Okay. I'm going to try to move that. Okay, let me do this. All right. Good morning, everyone. I am Attorney General Chris Mays. Thank you for joining us, and I want to thank especially Dr. Jill Gibson, Dr. Schnorr, and Dr. Edwards Jackson for being here with us today. Over the last several months, I have met with dozens of emergency room doctors, nurses, pharmacists, chief medical officers to hear their concerns about Arizona's extreme medical abortion bans. And these meetings began after the Arizona Supreme Court upheld the 1864 near total abortion ban following the U.S. Supreme Court's decision in Dobbs overturning Roe v. Wade. Those seismic changes in the law and the strict abortion bans that have followed have put healthcare professionals in Arizona in impossible situations. When women had a federal constitutional right to abortion, doctors could focus on caring for their patients and what their health required. But that changed when the U.S. Supreme Court took that fundamental right away after 50 years. Now, in large part because of restrictive abortion laws like Arizona's 15-week ban, doctors have a fear of prosecution hanging over their heads. And that is chilling how common sense medicine should be practiced. That fear now very often is compelling doctors to involve lawyers in decisions that should be solely between them and their patient. As just one example, an ER doctor recently said to me, "Chris, how close to death do I have to let a woman get before I can treat her and be confident that I won't be prosecuted?" This is an outrageous position for any doctor to be in the United States of America and in Arizona. But it is the reality that many providers face on a daily basis in Arizona. I don't write the laws, but it's my job to provide guidance on what those laws mean, to eliminate unnecessary confusion, and today we are doing just that. Arizona's 15-week ban includes an exception that allows doctors to perform abortions in a medical emergency both before and after the 15-week mark. In the Attorney General's opinion issued this morning, we are providing as much clarity as possible for medical professionals about what that medical emergency exception means. This brings us to the question that was posed to me by doctors and formally by Representatives Judy Schwiebert, Stephanie Stahl-Hamilton, and Senators Christine Marsh, and Ava Birch. When does a medical emergency exist under the definition in ARS 36-230-21-7, allowing doctors to provide an abortion? The text and legal authorities are straightforward and clear about what this means. To comply with the medical emergency exception in statute, the treating physician must do two things. 1, that physician must exercise clinical judgment. This involves applying personal knowledge, training, experience, and discernment to the facts in light of the patient's unique circumstances and other medically relevant conditions and considerations. And then second, the physician must determine in good faith that based on clinical judgment, either a condition so complicates the medical condition of a pregnant woman as to necessitate the immediate abortion of her pregnancy to avert her death, or a delay in providing an abortion will create serious risk of substantial and irreversible impairment of a major bodily function. Good faith means an actual and honest belief without malice or intent to deceive. Once a treating physician forms a good faith clinical judgment that one of these circumstances is satisfied, the statute allows her to perform an immediate abortion, and she need not wait for the patient to deteriorate or inch closer to death. And I think that is very important. The physician does not have to wait for the patient to get closer to death to act under one of the two conditions in the medical emergency definition in law. This clinical judgment that a medical emergency exists cannot be second-guessed after the fact and cannot be prosecuted under ARS 36-2322A or B, or any other abortion law with the same medical emergency exception, unless there is proof that the doctor acted in bad faith or acted without good faith. Big picture, it is really important to remember that in many instances where a medical emergency exists, these are very tragic circumstances, and often these are desperately wanted pregnancies where families are heartbroken to be ending the pregnancy in order to preserve the mother's health or life. And in some of those tragic cases, risk and additional heartbreak could have been avoided by allowing abortions before the medical emergency arose, but after 15 weeks. Again, I can't change the 15-week law, but I can try to provide clarity on what the medical emergency exception means so that doctors like these are not needlessly confused and patients aren't needlessly suffering and dying for lack of health care that doctors are allowed to provide. So as the top legal officer in the state, let me be perfectly clear. Arizona law does not allow for the prosecution of a treating physician who exercises their clinical judgment in good faith to provide an abortion under the medical emergency exception, full stop. And I have said before, and I'll say it again today, I will not prosecute any physician, nurse, doctor, or pharmacist under our state's abortion laws. I am making it clear to all county attorneys that the law does not allow you to prosecute medical providers acting in good faith according to their clinical judgment and providing abortion care in medical emergencies. And I would encourage all healthcare providers and their lawyers to read this opinion and determine how best to disseminate that information to instruct their doctors accordingly. I thank you in advance for doing that important work on behalf of all Arizona families. And with that, I'd like to hand it over to Dr. Gibson first to explain why this opinion was necessary. Dr. Gibson. Careful, you
Excuse me.
step up if you need it.
Perfect, thank you. Good morning, everyone, and thank you so much to Attorney General for her ongoing, tireless support of access to abortion and for providing me the opportunity to share my perspective today. My name is Dr. Jill Gibson, and I am the Chief Medical Officer at Planned Parenthood, Arizona. As an obstetrician gynecologist who has cared for thousands of patients seeking sexual and reproductive health care, and the mother of 3 young girls, I know firsthand that access to abortion for all people is absolutely essential and can be life-saving. Yet our reality here in Arizona is that abortion remains heavily regulated, and significant ambiguity exists surrounding the terms in which I am allowed to meet my patients' needs for abortion. Speaking from years of experience, the truth is that medical care is nuanced and complex. No matter what anti-abortion extremists want to tell you, the practice of medicine cannot be dictated by legislatures or courts. The provision of medical care, including abortion care, is individualized to each and every patient and their specific circumstances. These decisions regarding their care are communally made between a physician and her patient through a trusted therapeutic relationship founded on the underlying principle of all medical care, which is to do your absolute best to heal the patient. The draconian parameters created by non-medical lawmakers cannot and do not capture the nuance that is required to deliver medical care. To be a physician in this state and to have the knowledge of the right thing to do for a patient, and the skills and the resources to do the right thing for the patient, and to not be permitted to deliver that care for fear of criminal prosecution is amoral and antithetical to the ethos of medicine. Let me tell you about what happens when physicians are afraid to practice medicine. Following the Dobbs decision in 2022, OBGYNs were understandably confused about criminal prosecution for participation in any part of obstetrical care that was not completely straightforward. And let me tell you, obstetrical care is never straightforward. A respected colleague of mine was caring for a patient on the labor and delivery unit who was in preterm labor at 20 weeks. The delivery was inevitable, and due to the early gestational duration, the fetus would not survive. The patient had no anesthesia, no epidural. The simplest technique to expedite the delivery and relieve this pregnant mother of the pain of her contractions was to break the bag of water, which is the standard of care intervention. This obstetrician did not feel that she could perform this intervention for fear of being accused of participating in an abortion. So the pregnant mother languished in labor unnecessarily. Had that pregnant patient been in this situation because of an infection, one of the leading causes of preterm labor, the extra time she labored could have potentially resulted in sepsis or even death, in addition to her unnecessary suffering. I practiced obstetrics for 9 years before I came to Planned Parenthood. I took care of patients in a hospital that didn't allow abortions, and I cared for patients who had their water break dangerously early, at a point when a fetus is not viable and cannot develop naturally and normally. We either cruelly were forced to send these patients home, to wait for them to start bleeding and laboring on their own, or admitted them to the hospital, waiting day after day in agony for any clinical indication of infection, so that I would then be allowed to deliver humane and desired care and finally be permitted to end a pregnancy that was never destined to succeed. I'm thinking also of a patient that I cared for who was undergoing chemotherapy for lung cancer. Her treatment team wouldn't continue her chemotherapy when she discovered that she was unexpectedly pregnant in the 2nd trimester. She was frantic, trying to race through all of the loopholes. She was frantic, trying to race through abortion regulatory hoops to obtain an abortion before the arbitrary 15-week cutoff, all the while being denied the life-saving treatment for her disease. Imagine being told you can't access the drugs you need to fight your cancer, but that you also can't access the abortion that you need in order to access those drugs. This example illustrates how outrageous and inane restrictions result in real-life devastation for patients. And I want to tell you that I've heard loud and clear from our patients that they have lost trust in the medical system. They are fearful that they will be stigmatized, treated poorly, and denied care. My patients ask me, if I have to go to the emergency room, can I just say that I'm having a miscarriage? Will they be able to detect the abortion medications in my system? Will they take care of me if they know that I had an abortion? And I'd like for the answer to that question to be a resounding yes. What I want to say is, from the perspective of a physician, please don't tie our hands. Please don't make us sit and watch our patients suffer in front of us. Let us use our years of education, experience, and medical expertise to provide care that is dignified and based on our good faith clinical judgment, without fear of criminal prosecution. If we are not allowed to, our patients will die. Thank you, and I'd like to pass the microphone to Dr. Edwards-Jackson.
Hi, I'm actually going to go before Dr. Edwards-Jackson. My name is Dan Schnorr. I'm an emergency physician, board certified, practicing in the community in Phoenix right now. And so I can say, as emergency physicians, what we could see in the ER, we're not dealing with elective abortions. We're dealing with abortions that are needed in order to save the life of the mother. So this can happen in a few different ways. You could have a woman coming in who's bleeding excessively, maybe because of a problem with the placenta. You could have a woman that has a rupture of membranes and has an infection. And we can stabilize those patients with antibiotics. We can stabilize them with blood, but ultimately you get to a point where the antibiotics and the blood is not going to do enough, and they need to have an abortion, which is not an elective abortion. And so in those cases, some people could come back and say afterwards, I'm not sure. A lawyer could come back and say, I'm not sure that you actually needed to do that. You could have given more blood, you could have given more antibiotics. And as physicians, we're concerned that we're at the bedside with the patient, and then later on somebody who maybe has some kind of agenda is going to come and sue us. And honestly, up until this ruling, we didn't know what we were supposed to do in this type of situation. We all know what we're supposed to do. We're supposed to talk to the patient and do what they want and do what's in their best interest. But a lot of us were very concerned that we were either going to have to choose between the patient or being prosecuted. And so I just, I don't speak on behalf of all emergency physicians. I only speak on behalf of myself, but I think that my opinion is probably held broadly within my profession in Arizona, that this is a very welcome opinion from the Attorney General. This makes our job so much easier. We're just going to be able to provide the care that we know is right. And it's unfortunate that it had to take this opinion, that the Attorney General had to actually weigh in on this, but we really do appreciate that happening. So thank you.
Hi, I'm Dr. Edwards-Jackson, and I want to thank Attorney General for having us here today and for presenting this opinion. I am not an OBGYN, I'm not an emergency physician. I am an inpatient pediatrician. So that means I take care of sick infants, children and teens. That includes teenage moms as well. And as has been mentioned before, medical care is super nuanced, super complex. You have to, as a doctor, you're taking in all sorts of different pieces of information, and the patient, looking in front of you, their history, their lab test results, their imaging. There's multiple factors that go into determining the medical care for patients. And to have in the back of your mind worried of prosecution for doing something that you know is right for your patients by providing them with a medically needed abortion, and having that impact the care of your patients, that is horribly terrifying to all physicians, especially physicians who are taking care of sick patients like myself and Dr. Schnorr in the hospital setting. Also, as a pediatrician, I just always think of things from a health equity lens. I became a pediatrician because I believe that all children should have the equal opportunity to live a healthy and happy life. That includes young adults and young teens, young teen moms. And we know that historically, moms from lower socioeconomic status, moms who are women who are women of color, have had less access to abortion care in the past. One of my concerns as well, from a health equity perspective, is in the situation where a physician is sort of weighing the risk of prosecution to what's right to do for the patient. Women who have fewer resources, they're less likely to litigate or sue if a doctor doesn't make the right medical decision. And so for me, I think that it is a health equity issue from that perspective, because having a doctor who is focused on the risk of litigation rather than doing what's best for the patient is something that I think is truly not a right. And so, yeah, I appreciate your having us here today, and yeah, that's it.
Thank you, doctors. All right, we would be happy to answer any questions that you. Of course.
Of course you do.
Howard.
Let me ask two. The simpler one is the 15-week law has no exceptions for rape or incest. Is there anything in your opinion, that could, in your mind, allow a doctor to decide in good faith that a rape or incest situation fits within the definition of allowing a post-15-week abortion?
I mean, it's an interesting question. I want to also point out that we have with us Josh Bender, my Solicitor General, who, along with his team in our Solicitor General's office, including Lucy Davis, helped, and Haley Crawford, who are members of our reproductive rights unit, craft this opinion. I think the thing that comes to mind in answering that question, obviously that's one of the awful aspects of the 15-week ban, as well as the 1864 ban, which is that these bans contain no exception for rape or incest. But within the law that the legislature passed, and keep in mind, I mean, it's very interesting, we are interpreting the very law that the legislature passed, the 15-week law. Within that law, the legislature stated that in the second prong of the medical emergency definition, which is to prevent significant injury to a major bodily function, those things include the immune system, normal cell growth, the digestive system, the bowel system, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. And I think it's also important that the word includes was used. And so, I think that a doctor looking at all of that could use their clinical, good faith clinical judgment and make a decision. So, I don't know if Josh wants to add to that, but
I'm not sure I hear an answer in there.
Well, look, I mean, the opinion here is broad. It is not prescriptive. It does not list all the scenarios and situations in which a doctor may decide in their good faith clinical judgment that an abortion past 15 weeks is necessary. The law itself was very broad. And I think one of the issues one of the reasons that I think there has been confusion is that folks have been not really focused on exactly what the law says. So, number one, there are two parts to it, right? There is to avert death. And by the way, it doesn't say to avert imminent or certain death. It just says to avert death, which, as our opinion points out, means future death. And so that, I think, gives doctors latitude to decide that what they need to do is provide an abortion to prevent future death. The second prong of the medical exception is that the doctor may provide an abortion post 15 weeks to prevent injury, serious risk of substantial and irreversible harm. And so I think that folks have forgotten about that second prong, and that is a very, very important second prong that says that a doctor may provide that abortion after 15 weeks if the doctor believes in their good faith clinical judgment that not providing the abortion will result in a serious risk of substantial and irreversible harm. And I would add that nothing in the statute prescribes a percentage of risk necessary. The doctor's clinical judgment must be exercised in good faith to determine that. So when you actually look at the law, there is a lot of room for doctors. And one has to presume that the legislature deliberately did that. Another example that we point out, sorry how I'm going on and on and answer your question. No. Another example of this is that the legislature made this a subjective standard, not an objective standard. In other words, they said it is in the doctor's good faith clinical judgment to determine whether there is a medical emergency that has to be addressed. You know, the legislature could have made it an objective reasonableness standard in which the doctor's judgment would be compared to another doctor's judgment, but they did not do that. They merely said the doctor must have a good faith, honest, clinical judgment, and then decide whether prong 1 is met or prong 2 is met, to avert the death of a woman or to prevent that substantial bodily harm. Stacy?
Just a point of clarity to make sure I'm understanding this opinion right. So there are two prongs in the 15-week law: to avert the death or prevent impairment of a major bodily function. And so your opinion says in either of those, the doctor has to make a clinical judgment and be acting in good faith?
Yep.
Okay, I just wanted to make sure.
Correct.
When you talk about folks who are forgetting that there is the prong for a medical, impairment of a severe bodily function, who are you talking about?
Well, I just think it just in general wasn't well understood by the medical community and by a lot of other folks, including maybe the legislature. Maybe they forgot what they wrote. But we have heard from a lot of doctors that they were really sort of focused on the notion that they had to prove that the woman was within inches of death. This is why we're hearing stories of women being sent out to the parking lots or women being sent home until they get closer to death. That's just not in the law. And so we really felt it was important to give doctors assurances that they don't have to do that. There is nothing in the 15-week abortion ban that says that doctors have to allow women to get close to death's door. But you know, I mean, I certainly don't blame the medical community for this. They're dealing with everything that they're dealing with on a nightly basis. They have a lot to deal with. But they've now been thrust into a situation in which they're having to call their doctors. They're having to call their lawyers at night or anytime during the day to consult with them about this law. And so I think what the point is to get this information into the hands of chief medical officers at their hospitals, and that for those chief medical officers to disseminate that information down to the doctors to say, hey, there's a lot of room in this law for you to make your own clinical judgments about whether a medical emergency exists, and there's these two different prongs in addition to that. Howard?
Come back to the second question, which gets into the whole good faith. You've taken certain things off the table that can be used criminally or in civil litigation. Aren't you just going to open the door to people coming in and arguing Dr. X did not have a good faith basis? Whether it's some county attorney from, let's say, Yavapai County, or whether it's some parent who says, the father who says no, they shouldn't. Aren't you just opening the door to just changing the nature of the litigation?
No, I mean, we're not opening the door. The legislature wrote these words. I mean, these are the words of the legislature. And as we point out, and let me go to the page where we talk about good faith. If you go to page 4 of the opinion, we point out that the good faith clinical judgment is number one in the law. That the plain meaning of good faith is in all over case law. It's in the dictionary, and it means lacking in a dishonesty. It means lacking deception. It means without malice. That's the plain meaning of the words that the legislature used. And then clinical judgment, I think it's also important to remember that clinical judgment is not defined by the legislature at all in the statute, and never has been. And for good reason, because again, in case law and amongst physicians, clinical judgment is commonly understood. That their clinical judgment based on their training and their expertise and the circumstances in front of them is to be utilized. And so, these are the words that the legislature used, and we're just interpreting the way most courts have interpreted them, and in the way they are defined in the dictionary.
Attorney, I'm just wondering if you have any reaction to today's or this morning's decision from the Supreme Court to allow, for now, emergency abortions in the state of Idaho.
Yeah, obviously it's a great decision for the state of Idaho and for the women of that state. This is the EMTALA decision by the Supreme Court. I think it just points up how important this issue is, and how important it is for our doctors to be able to address medical emergencies that are in front of them in their good faith clinical judgment. As you all know, women were having to be air evac'd out of Idaho during that entire challenge to the Supreme Court. So I think the court has bumped it back down to the district court, and we'll see where it goes from there.
On that, Justice Brown Jackson complained that the court shouldn't have sidestepped the legal question of whether that statute actually conflicts with federal law. Do you happen to agree with her?
Well, I'm not going to disagree with Justice Brown Jackson on that. I'll let the Supreme that play out. Obviously, it's now been sent down. I mean, I agree with where I think she stands on the issue, but we'll see how it plays out going forward. Yes.
So we've been telling the public with this 15-week law that there are no exceptions for rape or incest, and I feel like maybe I've been saying that wrong. So I don't know how we should be telling the public that.
You know, I mean, both of the laws do have language saying there are no exceptions for rape or incest. But they're, you know, obviously I guess they're, you know, I don't want to get into scenarios in which, you know, these doctors and others can make their own good faith clinical judgments on those situations. But there could be co-occurring dangers, medical emergencies associated with those situations. And just because it was the result of a rape or incest, I mean, obviously that could happen. You could have co-occurring situations where there is a medical emergency. Then there is the mental health of the woman. And suicide has been addressed in case law in prior years. So those are all situations that I think doctors would be able to look at.
When we're done with the abortion questions, I do have something.
Okay.
Wait, can I ask you a question? So you're saying existing law allows for consideration of mental health impacts as a medical?
Well, I mean, the question becomes whether it's a major bodily function.
Well, suicide
Right.
is a major bodily function.
Yeah, you're
so-
dead after a
Okay.
suicide. So I
let's
mean,
get back to the question. You know,
Yeah.
it starts where I started. You know, which is in any way a patient's mental health.
I think it's up to the
depression, suicide, anything like that. Does that become an acceptable medical emergency?
Well, let me put it this way. The legislature was silent on that question. The law says, and let me read it to you again, okay? Read it to you again. Go back to what the legislature said. Major bodily function includes immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. Includes. It doesn't exclude what a doctor might consider other major bodily functions. And I'll leave it with that. Josh, do you want to add anything to that?
You want to step in this?
Yeah,
Josh?
please, yeah.
You know, I think part of what we were this office was trying to do in this opinion was provide some parameters and clarity for doctors, but we very explicitly were not attempting to address every different situation in which a medical emergency might arise, because ultimately we're not doctors, right? And there are innumerable medical situations, and so we didn't deal specifically in the opinion with, you know, PPROM or cancer or all of those different things, because those require all the facts that you need when you're looking at a patient. So we also didn't look particularly at mental health or this mental health situation or that mental health situation. And I think the broader point is the medical emergency definition applies when, in the physician's good faith clinical judgment, one of those two things that the Attorney General was talking about exists. An abortion is necessary to avert death or the substantial impairment.
Sir, can you state your name and
Oh.
position? Please be careful.
Yeah, sorry, we got this.
I'm Josh Bendor, and I'm the Solicitor General for the Attorney General.
You're not normally that tall.
And I'm not normally this tall, but it's a welcome
All right,
change.
we got time for a couple more.
Could we ask the doctors to do the same, just so our stories are accurate? If you could just spell your first and last name.
I'll send them to everybody. I'll send them to
Oh,
everybody.
okay.
Yeah.
Let me ask a non-abortion, non-Ohio, but a Supreme Court question.
more question? Okay.
Your predecessor, Mr. Bertovich, I know you curse every time you hear, never mind, had an ongoing fight with Purdue and the Sacklers over the issue of their personal bankruptcy, clawing back money and everything else. Supreme Court this morning blew up the bankruptcy settlement, which includes a bunch of your money, and said maybe we're going to let it go back and go after the Sacklers, but which also upsets the whole apple cart with your money. I was wondering what your view is of what the Supreme Court did and said, and how that affects Arizona.
Well, first of all, I guess the governor and the legislature think it's their money, but
Well, leaving aside your
leaving aside
your turf fight.
who has the authority to direct that money. Yeah, we obviously we saw that decision. It came in this morning, and we're reviewing that decision. And so just so everybody knows what Howie's talking about, the Supreme Court ruled this morning that the bankruptcy code does not permit the non-consensual third-party releases that the Sacklers had negotiated as part of Purdue Pharma's Chapter 11 bankruptcy plan. As a result, Purdue's Chapter 11 plan, which included a shareholder settlement that would have resulted in approximately $101.5 million in opioid abatement dollars flowing to Arizona, has effectively been tossed. We believe that the Sacklers and Purdue Pharma must still be held accountable. We believe the state of Arizona is still due at least $101 million. There are other elements of the Supreme Court's decision that actually open the Sacklers up, I believe, for even more liability from individuals. So the Sacklers were, I believe, the first and some of the most egregious actors in the opioid crisis and in causing so many deaths in America and in the state of Arizona. And we are going to fight like hell to make sure that that money comes to the state of Arizona. We don't know what our path forward is yet, but we're looking at it.
Had this office taken a position, a lot of states filed briefs, had this office taken a position on whether to allow the bankruptcy deal to go forward or whether to blow it up?
I don't think so, but I can double check on that for you. Yeah, Stacy.
Could you give us an update on your office's investigation involving potentially the governor and Sunshine Residential Homes, that situation?
I tend not to do midstream updates on investigations.
I mean, just between us.
And the rest of the world.
Yes.
But I will say this, we are engaged in a very serious, significant professional investigation into the Sunshine matter and the governor. We will do that investigation. We will take the time that is necessary to do it. I have multiple agents working on it right now. We'll have an update for you when it's done.
Don't call us, we'll call you.
Yeah.
All right, any last questions?
Okay, thanks everybody for being here. Thank you, doctors. Appreciate it.